Welcome once again to Lehto's Law. Here's Steve Lehto.
We've talked before about searching cars. When the police search your car, when can they do that? What excuse do they need to do that if you don't give them your permission? So trick number one is they'll walk up and say, do you mind if we search your car? And if you say, sure, go ahead, well, then they can search your car. But if you say, no, I don't want you searching my car, and they really want to search your car, how do they go about it? Well, one way they do it is they use an inventory search. And we've talked about a related issue with those safe deposit boxes in Beverly Hills, where the FBI got permission to seize the boxes, but not the contents. And then, of course, once they have the stuff in their possession, they have to inventory it. So they inventoried it, which meant they got to go through the contents of those boxes. So what they'll often do is, if they can't search your car, they'll come up with an excuse to tow your car. And when your car gets towed, well, they've got to do an inventory of what's inside of it, right? Well, it turns out, and this article is from Tech Dirt, written by Tim Cushing, that the 10th Circuit Court of Appeals has said that pretextual inventory searches need to be a whole lot less pretextual. In other words, they need a better reason. They can't just tow a car so that they have the excuse to inventory it. One of the great warrant exceptions is an inventory search. They can stop a car in a high traffic or high crime area, and officers will feel compelled to tow it away. Of course, they have to make a list of everything in the car to ensure the vehicle's owners get all their possessions back. And of course, while they're doing that, they find something not good, and look what we found. Contraband. So that's a win for the cops. The discovery will be called inevitable and can be used against the person to deprive them of their freedom along with their car. So this simple trick usually works out for law enforcement, but every so often, it doesn't. And when it doesn't work, it's usually because officers are in such a hurry to carry out the warrantless search that they completely forgot about the pretext. They need to have an excuse, even a thin one, but they need an excuse. So that's what happened in this case in the 10th Circuit Court of Appeals. The defendant brought a motion to suppress, and the lower court denied it, but the 10th Circuit Court on Appeal reversed it, finding that the officers created an excuse to search the car, which made their discoveries less than inevitable, and therefore the stuff would get thrown out. This all happened in Tulsa because a caller said that a person was in the middle of a drug case and may have smoked something illegal and may have also had other issues like violating a protective order and maybe some other stuff. So kind of a vague tip-off. So the officers went out to find the guy, and they were trying to serve him with an outstanding warrant. So there was an outstanding warrant and apparently a protective order that they thought he might be violating. But here's what happened, according to the actual opinion. Police officers found the man in Tulsa at about 8 a.m. and initiated a traffic stop. He pulled into a parking lot of a convenience store and stopped there. The police told the man to get out of the car. They arrested him based on the warrant, and they took his cell phone. He then asked if he could call someone to pick up his car. One of the police officers said, I don't think so. And the police decided then to impound the car. But it's not that simple. The stop and search were captured on the officers' body cameras, which caught them talking about what they needed to do to come up with an excuse to search the car. And so rather than performing a regular inventory in preparation for towing the vehicle from the convenience store parking lot, one officer looked in the panel on the driver's side door and on the floor under the driver's seat, saying that they were somehow investigating a huge drug case. The other officer replied that the defendant likely had used drugs, and as he was saying that, he opened the center console. So they're searching the car before they even discussed towing it. An officer commented he was looking for verification of car insurance. I'm just looking for your car insurance. It's in here somewhere, right? He expressed doubt that the man had insurance on the car. And after seeing no verification in the center console, he eventually found a proof in the glove compartment. But, of course, in the glove compartment, he found some other stuff, which is contraband. So they said, look, we were simply looking for his proof of insurance, and we found some other stuff along the way. And they didn't even bother getting to the impounding of the car. So using this evidence, they obtained a warrant to search his phone, and there they found text messages that indicated the man was, in fact, involved in some kind of illegal activity. So The court talks about prior precedent from that circuit restricts officers' ability to impound vehicles, which accordingly also limits their ability to search vehicles without a warrant. So in other words, they can't say, look, we would have found all this stuff because we were going to impound his car anyway. Because you can't just impound cars because you feel like it. These heightened requirements allow impoundments from private property when the car is blocking traffic, the car is posing an imminent threat to public safety, or the impoundment is justified by a standardized policy and a reasonable non-pretextual rationale of community caretaking. The man's car was parked in a parking space in a private parking lot, and he said, I can have someone come and get it. They said, no. We need to impound your car, but after we search it and find stuff we would have found when we impounded your car anyways. It's amazing how they can do that kind of thought process. The Tulsa PD's impound policies comply with this precedent. As conceded by the state, officers can only impound a car if the vehicle is blocking the public way or if the vehicle is stopped on private property. The traffic stop follows an offense committed on the public way. In this case, the stop did not follow a traffic violation. It was performed to serve a warrant. Hence, the impounding and the attached search were unjustified, and the government's arguments cannot change that. Here's the court writing. The police stopped the man to serve a protective order and execute an arrest warrant for public intoxication, but that public intoxication had occurred earlier. The protective order and warrant were pieces of paper, not offenses. The only offense was public intoxication, and that did not take place on a public way, nor at this moment in time. The government contends that the man was stopped for a continuing offense, failing to pay costs for his charge of public intoxication. But failing to pay court costs is not a continuing offense. Plus, there were things said by officers that made it clear they were only interested in searching the car, rather than ensuring it wasn't left on private property where it might have bothered the owner of the convenience store or been molested by an unspecified criminal element, which is one of the things that the defendants also said. Or excuse me, one of the things that the state also said. We're doing this to protect the man, to protect his car. While the government presented a long list of reasons it could have impounded the car, the officers stated none of these reasons before performing the search, nor afterwards. These reasons didn't make an appearance until the search was challenged, indicating the impound was mere pretext for the warrantless search of the car. So the article is quite lengthy, and I have to commend Tim Cushing and Tech Dirt for talking about this, because this is a legal issue that pops up a lot. By the way, Keith sent me the story. Thank you very much, Keith. And police, if they want to search your car, they can ask, you can say no. And then there's different ways they can search your car legally if certain circumstances occur, but without those circumstances, they're out of luck. And once in a while, I got news for you, you don't get everything you want in life. Once in a while, you will be disappointed. So if you're a police officer and you want to search every car you pull over, I got news for you. You can't. You're going to be disappointed. Sorry to break the news to you. They should tell you that at the academy. Once in a while, you're going to pull somebody over, you're going to want to search your car, and there's not going to be any excuse you can make up. But the pretextual searches, where they invent a pretext, and everyone knows this. And I've done stories on this, by the way, too, where they pull somebody over, and they can't come up with a reason to search the car, so they come up with a reason to impound the car. And once they can impound it, they can search it. By the way, if you were to ask the average person, your car is about to get towed to an impound lot. If you want to, you can lock the doors and toss the keys to the tow truck driver and not have your car searched. Or you can have the police take an inventory of your car and search it from top to bottom, and then all your stuff will be safe. Which would you prefer? Most people would say, I'd rather just leave my stuff in the car. And, I've mentioned before, I used to tow cars. I used to tow cars for the Birmingham Police Department, Birmingham, Michigan. And I don't remember seeing them ever inventory cars. But I can also tell you that the impound lot was locked. No one had access to it. And when I towed a car there'd be a police officer to open the gate up. I'd tow the car in, unhook it, leave it. He'd close the gate behind it and lock it. And there was barbed wire around the top. No one got in there to mess with those cars except the police. So when they're inventorying the contents of a car so the stuff doesn't turn up missing later, at least in my instance, they're basically saying we're doing this so we don't steal your stuff. Now, I understand there are some places where cars are towed to private impound lots. and the possibility that stuff might disappear down there, it could happen. But guess what? When you come back and the window's smashed out of your car and your stuff is gone, and they go, but hey, look, we have an inventory here for you. We can show you what was in your car before the window was smashed and your stuff was taken. And you go to the impound yard and you say, hey, my window is smashed, my stuff was taken, here's an inventory report. They're going to say, huh? We didn't fill that out. Cops filled that out. Maybe they took your stuff. You go, what about the broken window? Broken one, we got it, as far as we can tell. Trust me, that inventory ain't going to help you any anyways. So it is a pretext that the 10th Circuit Court wisely has said, you know something, guys, you got to come up with better excuses at least. So it's good that the courts of appeal can get it right from time to time. Keith sent it, thanks a lot. Tech Dirt published it. Tim Cushing wrote it. Like I said, it's a lengthy article and a lengthy opinion. 10th Circuit says pretextual inventory searches need to be a whole lot less pretextual. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A train station is where a train stops. On my desk, I have a workstation where my work